what I am saying is the act of sexual intercourse is good. It is not a bad thing. The issue is the timing of sexual intercourse. So that when you are below the age of maturity or when you are below the age of social responsibility, then ideally you need to be careful before you engage, because then you'll be going into a place of issues. But, and that is the way we should teach sexuality to the children, that it is not the act of sex that we are worried about, is whether you are ready to indulge and whether you are ready for the responsibility that comes with it. And that is what I mean. The other thing is that the brain of the human being is the last organ to mature in the body. And whereas we have said sexual maturity occurs by the age of 14 or thereabouts, plus or minus, the part of the brain that helps us with reason, making good decisions, does not mature until about 21 to 26 years of age. So we have an adolescent person who is sexually mature, but is incapable of making good choices, good reasoned choices, before they are at least the age of 21. So even the age of 18 is basically a compromise. So that said, in the social media, there have been many questions. People are asking where in the bill is abortion legalized? Where does it relate to gay and lesbian relationships? Where does it advocate for same-sex marriages? Where does it encourage underage sex? Where does it encourage rape? Where does it encourage bestiality? And in order to understand these things, fellow senators, honorable senators, we need to understand the sexual and reproductive health and rights ideology. And the sexual and reproductive health is an ideology that is inconsistent with our Christian faith. And it has about three components, basically. There is a component that is the Enlightenment component. Enlightenment is a time when human beings decided the spiritual world is not relevant, and that science can basically explain human existence without God as a creator. There is a reproductive health rights component and the sexual health rights component. And our main focus really and biggest concern is the sexual health rights component. Now, the sexual revolution is a factor of the French Revolution. And during that time, there is a gentleman called Wilhelm Reich, who basically wrote a book by the same name called The Sexual Revolution. And Wilhelm was deeply hostile to Christianity. He believed that science and metaphysics are mutually exclusive, that the two cannot relate. And he believed in absolute sexual freedom. And therefore, what he wrote in his book is that it was necessary to abolish lifelong monogamous marriages. It was necessary to encourage infantile sexuality, because suppressing it, in his view, led to perversity in late life. To promote frank sexual education and sexual freedom for adolescents. That abstinence is pathological, and freedom for people with abnormal sexuality, such as homosexuality, to pursue their inclinations. And he also recommended for the legalization of abortion. Now, Wilhelm Reich lived between 1897 and 1956. So, this component of sexual health, sexual reproductive health rights, was first attempted to be introduced into international documents in the ICPD conference in Cairo in 1994, the first ICPD conference. And the terms reproductive health, reproductive rights, sexual health, sexual rights were introduced. And it is important to know that these rights are not, these terms are not universally acceptable. And that their use, like my colleague has said, can be a major problem. The sexual rights were later expounded in the 13th Congress of the Sexology run by the World Association of Sexual Health in Vienna in 1997. And then in 2011, IPPF came up with a declaration of sexual rights. IPPF is the largest provider of abortion services in the world. They also developed the Comprehensive Sexuality Education Framework, which encompasses sexual rights and sexual issues. Now, the most dangerous document to us is the World Health Organization document that is called Sexual Health, Human Rights and the Law, which came in to define sexual reproductive health and rights. This document was published in 2015 and is co-authored. Yes.
Sorry to stop you for a bit.
Yes.
I just also want you all to know that we also have a time frame for the presentations so that everybody is able.
Section 3A has the term reproductive health rights. Section 3? No, Section 3?
2 and Section 3.
Yeah, this, the one I'm referring to is Section 3A, has the term reproductive health rights. 26(1)(c) refers to the termination of a pregnancy because of disability, whether mental or physical, and talks about those being reasons for terminating a pregnancy. We are also concerned about...
Now, Chair, just allow me kindly on the issue, because I represent persons with disabilities.
Yes.
And it would be mean of me not to comment on this, that even as I was looking at the bill, it is not saying that when someone has a disability, mental or physical, then termination can be there. Kindly let us understand the bill.
Okay, so allow me to interject to assist Daktari. Section 26(1)(c) says the following, that a pregnancy may be terminated, which means you can have a deliberate abortion, if, in the opinion of the trained health professional, there exists a substantial risk that the fetus would suffer from a severe physical or mental abnormality incompatible with life outside the womb. So basically, this is saying that because we see the fetus or the unborn child has a disability, we abort the unborn child. That is the meaning in law. So what we are saying is, if you have an unborn child with an abnormality or disability, there are two options that may happen.
Okay, Mr. Kanjama, surely.
Yes.
Please complete that sentence, because when you stay up to just disability, it gives, and I want us to be able to just be quiet on our side and let you all finish with your presentations. But sometimes when what you're saying is so off from what is on, you're not reading the part about being incompatible with life outside the womb. It doesn't just stop at a child with disability, because that clearly just...
Okay, I was explaining, I read the entire section and I can read it again. There exists a substantial risk that the fetus would suffer from a severe physical or mental abnormality that is incompatible with life outside the womb. So the focus is disability. That physical or mental abnormality is disability. And the question is this: are you going to deliberately terminate a child who you think has a disability? Normally, when someone has a disability intrauterine, there are two possible outcomes. The first is that due to the disability being so severe,
I think, Chair,
Let's proceed. Let's allow him to finish, but also don't misrepresent. But let us allow you to finish. But maybe to Dr. Wahome or you, or you're the one.
Okay, now. Okay. So when
yes, Honorable Millie Odhiambo.
Thank you, Chair. Chair, I think we need to agree on something, that the nature of this engagement is actually to seek consultation on specific clauses. We may agree or disagree, but I think let him have, in all fairness, let him have his own interpretation, so long as he reads all of it. Just read all of it. You may have your interpretation, which we may or may not agree with. And you might find that maybe some of us agree with you, some of us don't. But either way, I think what you need to do, because this is the essence of this part. It's about discussing and agreeing or disagreeing.
So,
Correct. So let's proceed.
yes,
Sorry, Mr. Kanjama, 1 minute. So we.
If every time we explain our position, you interject and explain yours, then we are not going to go very far. Because then we are arguing. We may have totally different views, we may have totally different historical backgrounds, but it's important for you to understand where we are coming from.
Sit.
Now,
Dr. Wahome, proceed.
Yes. Now, Article 27(1), it says a trained health professional who has a conscientious objection to the termination of pregnancy as envisaged under this Act shall, except in the case of emergency treatment, refer the pregnant woman to a trained health professional who is willing to provide this service. And then Section 26(2) goes on to offer punishment for one who has objected. Now, if the termination of pregnancy is based on the opinion of a trained health professional, why would you punish one who decides that, according to their professional opinion, there is no need to terminate this pregnancy? We can use the same example of the disability. If I am of the opinion that that pregnancy is not affecting the status of the mother, is not putting her at risk, and I say termination is not necessary, I have simply given my opinion, and she can go and seek a second, third, and fourth opinion. When you criminalize my opinion, then what you're saying is that termination on this may be mistaken to assume that termination on demand of the mother then is acceptable. And if I refuse to terminate her pregnancy, she can charge me in court for refusing to offer. So that is another major concern we have about the bill. Now, when it comes to the issues about whether it encourages same-sex relationships, the definition of reproductive rights that is in the bill, the definition of reproductive rights says, include the right of all individuals to attain the highest standard of sexual and reproductive health. The term sexual has come in, and we made it clear that sexual and reproductive health and rights is a different ideology, and these terms are taken to mean very many things, including what I was reading for you before I was interrupted. Under assistant reproduction, then 9(1), every person has a right to assisted reproduction. Now, every person, again, is a very broad term, and it can mean literally anybody, including children and others. But when you read that together with 14(1), a party may enter into a surrogate parenthood. So one person can enter into a surrogate parenthood arrangement. And section 14(1)(a) says, the commissioning parent or commissioning parents are not able to give birth to a child, and that condition is irreversible. So again, it brings in the issue about one person, one parent commissioning a surrogacy arrangement. Yet in medical terms, we talk about inability to conceive. By definition, includes a man and a woman who have had normal and protected sex for up to 1 year. So how would you define one person being infertile if they're not in union with somebody else? And then, like we said at the beginning, if this is to protect the family, then again, when you enter into surrogacy arrangements, then again, we would expect that the child would be protected by being provided with both parents. So that is one area. When you go to 16, An assisted reproductive health care provider shall not carry out artificial insemination with respect to a surrogate mother unless a surrogate parenthood agreement is duly signed and deposited in the assisted reproduction facility together with the medical documents prescribed under the law, under the Act. Now, if you are going to carry out a surrogacy arrangement where you do artificial insemination, then you are saying that the egg that will be used to get the baby belongs to the surrogate mother. And I would like you to understand that this is very different from IVF. IVF, the man in the relationship, the parents would give a sperm, the lady would give an egg, or they would get from a donor. This would be put in a woman who has no genetic relationship to them, and that surrogacy baby would then not be a biological, child to this mother. But when you use semen from a person into the surrogate mother, then that baby, the egg that produces that baby, belongs to that mother biologically. Now, when you come again to the a child born, that is why Article 19.2 is very important, because the child of a surrogate arrangement like that one is not supposed to claim anything from the mother, the surrogate mother, because biologically it is her child. It is her child with semen inseminated from somebody else, but she has given up that child to somebody else. The 19.2 is saying now that child cannot come and claim from the estate of its own biological mother. Now, 19.3 says parties to a surrogate parenthood arrangement shall not terminate the arrangement after artificial fertilization of the surrogate. So I wanted to bring that out again. You're talking about artificial insemination, not in vitro fertilization. So when you talk about one party being able to access surrogacy arrangements and using insemination, then there exists a potential of two men who are living in a relationship going to commission a surrogate parenthood arrangement. Now, does it encourage underage sex? Again, when you look at section 7.1, again it says every person has a right to access reproductive care services, but the adolescent should not be put at the same level as the adult. So that we agree, if sex below the age of 18 is not lawful, then the children who are below the age of 18 need to be given information about how to take care of themselves. They may need treatment if they have abnormal periods and things like that. But then reproductive health care services also includes contraceptives, it includes many other things. So it is important that when we are dealing with the adolescents, we separate the adolescent from the rest of the people, so that there are some services that would not be appropriate to give an adolescent child. So then there is Article 38, there is Section 38. It says the Cabinet Secretary shall make regulations generally for the better carrying out of the provisions of this Act. We already have Cabinet Secretaries of Health and of Education who went to South Africa and signed a ministerial commitment about comprehensive sexuality education. That arrangement is not binding to the country, but it is being used and is being quoted to push for comprehensive sexuality education in this country. I think it is too broad a leeway to give a Cabinet Secretary of Health to determine some of those things. Now, there was a question about encouraging rape or encouraging bestiality. Again, we go back to the definition of reproductive health rights, and like I told you, it includes sexual rights. Now, sexual rights are taught that pleasure is the right of everyone, and that everybody has a right to experience sexual pleasure. That's generally how it is taught, and that's why I was trying to explain to you the historical background of sexual rights. Now, what happens if a child, especially a boy child, wants to experience their sexual right now, and there is no person of the opposite sex who is consenting. So we have trained our children sex is a right, and that it is your right to experience sexual pleasure. What happens if we train our young men this way, and now they want to have sex, and there is nobody willing to have sex with them? That is the danger. And if you look at the documents that talk about comprehensive sexuality education, masturbation is supposed to be taught right from the age of 4. And that is part of the concern that we have. So, but
Okay, I'm really
just finishing.
no. Dr. Wahome,
comment,
we
yes?
cannot proceed that way.
Okay.
We need you to be factual.
Yes.
We need you to talk about what is in the bill, because we are already having such misinformation. I have told you like 5 times out there. So we cannot be having you as Dr. Wahome sitting here in front of us, bringing in things that are not in the bill, and then now using them to argue against the bill. It cannot work that way.
Can I read the definition again, please? Reproductive rights.
Hold on, Dr. Wahome. Honorable Pasaris.
I'd like you to take me.
Masturbation.
Yeah, I'd like you. First of all, you're a doctor, and you know, and you should know, irrespective of your Christianity or your religious background, you should know that masturbation is a natural process of any human being. It is. Now, the fact is that now you're saying that it should be taught. It's not taught. And where in the bill is it saying that it should be taught at the age of 4? Where? Take me to that clause. Because you're the ones who are actually causing so much confusion and denying women and girls the right to reproductive health care. And it's very sad.
I need you to protect me, Chair.
Okay, I will, Dr. Wahome, but kindly, just for the record, because you know we do have somebody here taking records, yeah?
Chair, can I say something?
No, hold on. You're here. Also, some of it might be live, yeah? So we do not need you with your title, Dr. Wahome, to be misinforming on what about the bill. We do not have masturbation for 4-year-olds in the bill. And if it is, I would wish and I would want you to point out where you're getting that from.
Can I continue now, Chair?
But point it out first.
Yes.
So point it out and then proceed.
Reproductive rights are defined to include the right of all individuals to attain the highest standard of sexual and reproductive health and to make informed decisions regarding their reproductive lives, free from discrimination, coercion, and violence. This, Chair, is what my colleague, Mr. Kanjama, has been alluding to. If you do not understand what sexual rights means, as defined by those who created that term, then you would not be able to interpret this bill.
Yes, Honorable Millie.
The term sexual rights is the term that can be abused to import all those things that I have said. And that is in the bill. My prayer to this House and to you, Honorable Senator Kihika, is that I see your passion, I see your intention, and it is a good one. But if we do not orientate this bill to be family friendly, then it is going to be a major problem. So my request is that we withdraw the bill and go back to the drawing table. We'll be able to discuss some of these things and come out with something that would be good for the country. Thank you.
Thank you, Dr. Wahome. Mr. Kanjama, is your group done so that we can...
mention. There are several things I wanted to mention as well as to respond to the question of Honorable Millie about where is masturbation in the bill. And the first thing I will say is you will not find the word masturbation anywhere in the bill. You will not find the word same-sex behavior or marriage anywhere in the bill. You will not find the word comprehensive sex education anywhere in the bill. You will not even find the word abortion in the bill. But all of those issues are matters that can come in through this bill because of our interpretive framework. And I want to spend 2 or 3 minutes talking about the interpretive framework of laws. We have the Constitution of Kenya, which already has said what reproductive health care is in general, Article 43. We have the Health Act, which is Section 6, has already said what is reproductive health. So we are not contesting those. We are asking what else is being introduced by the bill. I, as Charles Kanjama, on behalf of KCPF, have been in court in numerous cases debating what is the meaning of some certain phrases, what is the content of certain words. So, for example, you will find that if you include a certain word, but you omit another word or phrase, the word that you've included is capable of several meanings. It becomes ambiguous. And that is part of the concern we have. So our concern is not only with what is in the bill, is also with what has been excluded or omitted that would have helped to clarify the meaning or interpretation of certain phrases. So for example, in Section 2, there is a definition of adolescent-friendly reproductive health services. It seems to be a good definition, age and development appropriate. But the fact that it is not explained what are these age and development appropriate adolescent-friendly reproductive health services, the question arises, does this include contraception? Does this include morning after pill? Does it include services for people having teenage sex? That is the natural question that arises from that definition. There is a definition of, also under Section 2, there is a definition of pregnancy as a presence of a fetus in the womb. Yet, our Constitution recognizes a child as a person from the moment of conception. Where in the bill does it define pregnant, does it bring in the idea that there is right to life from the moment of conception? We are also concerned that certain words that humanize people like unborn child are omitted in the bill. So the unborn child is merely referred to as a fetus. We know fetus is a medical term, but this is a legal document which is founded on the Constitution and on the Children's Act. Can we also use some of the terms that are already available? We have the definition of reproductive rights as highest standard of sexual and reproductive health. The phrase sexual health is what Dr. Ohome has been trying to say. There are numerous documents. Some of them are policy documents at the international level. And these documents are the ones that are attached in court cases to tell us what sexual health means.